Good day, ma'am. My name is Analou Cardinas, BSHM 3A. I'm going to report Law on Partnership and Corporation, Chapter 4. Learning objectives. Differentiate the various kinds of partnerships and corporations and the responsibilities of partners and incorporators. 2. Identify the requirements in the formation and dissolutions of partnerships and corporations. Topic outline. Introduction. Law of Partnership. The essential requisites for a partnership, advantage and disadvantage of forming a partnership, classification of partnership, forms of partnership, obligation of the partner, dissolution and winding up of a partnership, order of liquidation for a general partnership, order of liquidation for a limited partnership, law on corporation, kinds of corporation, advantage and disadvantage of a corporate organization, corporate liquidation, and conclusion. In a high-level industry like the tourism sector, it is imperative that it strictly complies with legal requirements in order to operate as a legitimate business. Startup operation must have a strong foundation, and in order to have a strong foundation, you must start with a strong business organization. Forming a partnership or a corporation is a better choice in forming business organization in order to enter a competitive industry, like the tourism industry. This chapter will present an overview of a partnership and corporation as a business organization. The law on partnership is governed by the Civil Code of the Philippines, while the law of corporation governed by the Batas Pambansa 68 Corporations Code of the Philippines. The law. The Article 1767, by the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. A partnership is an association of two or more persons to carry as co-owners of a business for profit. The definition of a partnership does not include religious associations, conjugal partnerships, and others of a similar nature because partnership is defined by law refers only to associations, the purpose of which is to obtain profits to be distributed among the partners. A partnership is based trust and confidence. Hence, the fiduciary relation in a partnership stem from the principles of delectus personae, where no one can become a partner in a partnership without the consent of all the partners. The essential requisites of a partnership are: number 1, an agreement to contribute money, property, industry to a common fund. This is complied with A, which one of the partners brings or is obliged to bring something to the partnership, and that is brought becomes common property. 2. Intend to divide the profits among themselves. This is complied with a partnership is established to obtain profits. Profit must be common to all the parties, and profit or loss must be divided among the partners. Advantages of forming a partnership. Number 1, easy to form. 2, improved growth possibilities. 3, freedom from bureaucracy. Advantages of forming partnership. Number 1, instability. 2, difficulty in obtaining large sums of capital. 3, firm is tied to the engagement of one partner as agent. Definition of partnerships. Universal partnership. A partnership where all of the partners contribute all of their properties to the common fund and speaks of no particular purpose or subject matter, as long as the purpose of forming a partnership is to obtain profits and is not contrary to law, morals, public orders, and public policy. Nowadays, seldom if none do you experience business establishment forming a universal partnership. Particular partnership. A particular partnership has for its object determining things, their use of fruits or a specific undertaking or the exercise of a profession or vocation. According to liability, general partnership composed of general partners where liabilities extend to their personal properties. Limited partnership. One formed by two or more persons having as members one or more general partners and one more limited partners where the liability of the latter to the third person is limited to the capital contribution. And lastly, according to duration, partnership for a fixed term is one in which the term for its existence has been agreed upon expressly. The expiration, the term thus fixed, or the accomplishment of the particular undertaking specified will cause the automatic dissolution of the partnership. Forms of partnership. A partnership can be any form, even if not recorded at the Office of the Securities and Exchange Commission, except 1. When it's stipulated. 2. When immovable property or real rights are contributed, in which case there must be a public instrument to which is attached an inventory to the immovable properties and signed by the parties, otherwise partnership is void. Number 3. In case of limited partnership, the parties must sign the swear to a certificate which shall state, among others, the name of the partnership, adding the word limited and the character of the business. B. File of record the certificate in the Office of the Securities and Exchange Commission. Obligation of the partners. 1. Where contribution is money or property. If a partner promises to contribute money during the celebration of the contract and he fails to do so, he shall pay the interest and damages from the time he should have complied without need of any demand. If a partner promises to contribute specific determinate things, he must preserve the property, deliver the fruits from the time of agreement, warrant against eviction and hidden effects, transfer ownership on delivery to the partnership, pay damages for the delay without necessity of demand, and bear the risk of loss before delivery. Number 2. Where contribution is industry. An industrial partner, a partner who merely contributed industry or services to the common fund, cannot engage businesses for himself unless the partnership expressly permits him to do so, and if he should fail to do so, the capitalist partners may either include him from the firm or avail themselves of the benefits which he may have obtained in violation of this provision, with a right damage in their case. Number 3. Obligations of the capitalist partner. A capitalist partner, a partner who contributed money and property to the common fund, is prohibited from engaging in a business in a competition with a partnership unless there is stipulation to the contrary. Otherwise, all profits of such partner belong to the partnership, and all losses shall be for his account. Number 4. Responsibility between partnership and partner. The partnership shall be responsible to every partner for the amount he may have disbursed on behalf of the partnership. It shall also answer to each partner for the obligations he may have contributed in good faith in the interest of the partnership business and for risk in consequence of its management. Sharing of profit and loss among partners. The distribution of profits and losses shall be in conformity with the agreement. If only the share in the profits is agreed upon, the share in the losses shall be in the same proportion. A stipulation which includes one or more partners from any share in the profits or losses is void, but an industrial partner shall not be liable for losses. In the absence of stipulation, the share in the profits and losses shall be in proportion to the respective capital contribution, except the industrial partner, who shall receive a share to the profit as may be just equitable under the circumstances. Number 6. Property right for a partner. A partner cannot assign his right with respect to the specific partnership property as individual debts or for legal support. Number 7. Liability of individual partners to third persons. All partners, including the industrial partner, are liable pro rata with all their properties for contract with third persons provided. Number 8. Liability of the limited partner. A limited partner is liable as general when he allows his surname to appear in the partnership name, and when he takes part in the control of the business. Dissolution and winding up of a partnership. The law. Article 1830. Dissolution is caused, number 1, without violation of the agreement between the partners. by the determination of the definite term or particular undertaking specific in the agreement, by the express will of any partners who must act good faith when no definite term or particular undertaking is specified, by the express of all the partners who have no assigned their interest for suffer them to be charged for their separate debts either before or after the termination of any specified term or particular undertaking, by the expulsion of any partners for the business bona fide in accordance with such power conferred by the agreement between the partners. Number 2, in contravention of the agreement between the partners where the circumstances do not permit dissolution under any other provision of this article, by the express will of any partner at any time. Number 3, by any event which makes it unlawful for the business for the partnership to be carried on or for the members to carry it on in the partnership. Law on corporation. The law. Sector corporation defined. A corporation is an artificial being created by operations of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incidental to its existence. Law is not a law if it violates the principle of eternal justice. In conclusion, Chapter 4, Law of Partnership and Corporation, emphasizes the importance of choosing the right legal structure for tourism and hospitality businesses. Partnerships are simpler but come with the risk of personal liability, while corporations have limited liability, making them a safer choice for larger businesses. Understanding these legal options help tourism operators manage risk fund, and comply with the law, ensuring smoother and more secure business operations. That would be all for the Chapter 4. Thank you.